Here we go. Court is officially in session. Notice how the judge immediately sets the tone. Formal, precise, and on record. Every word counts from this moment.
We will go on the record in the matter 24 CF 110, State of Wisconsin versus Wesley Rayo Wolf. The state appears through Assistant District Attorney Kevin Schmidt in person. We have Mr. Rayo Wolf in person with counsel Albert Moustakis appearing in person as well. We're set today in this matter for the sentencing portion as well as the restitution portion of this case. Before I begin, I want to note, Mr. Moustakis, you did file what?
Close enough.
Moustakis?
Yes.
Well, see, I said Moustakis before, but then Ms. Thompson called you Moustakis. And so then I'm like, maybe I said it wrong. So then I made note to say it the other way. So, okay, Mr. Moustakis. Moustakis. You filed documents, 75 pages this morning.
Did you catch that? The defense attorney just dropped a 75-page document the morning of the hearing. That's like cramming for finals and handing your professor the essay at the last minute. Judges hate that.
I didn't have time to read it because I work.
I knew you wouldn't have time to read it, but
okay.
I couldn't get it filed till late yesterday, and I apologize for that because I'm very busy and I really had to review it and see if I thought it would be appropriate to file. I'm just going to summarize some things from it. It's more for informational purposes, and I'll indicate to the court that the court asked us a question at the last hearing, and it held up 2 pages of the diversion agreement. This article, it's an abstract from 2019, so it's fairly relevant and recent. Talks about the benefits.
They're talking about diversion programs, basically a legal second chance. Instead of straight punishment, it's a way to rehabilitate first-time offenders. But the judge is clearly torn. Justice for the victim versus giving a kid another chance.
Of diversion programs.
I'm well aware of the benefits of diversion programs.
Well,
I'm a proponent of diversion programs, quite honestly. And
Yeah.
I work with Mr. Schmidt, and once he is the district attorney here, we're going to meet to try and work even more to have diversion programs for Burnett County. So I'm well aware of diversion programs and the benefits.
I don't practice here.
But I did
generally.
not read this article.
It may be something you'd like to read in the future. I'm going to refer to some of the statistics out of it for purposes of that, because at the last hearing, the court made me feel like it didn't value diversion programs.
No.
Okay.
I value diversion programs. I also do understand consequences and accountability and responsibility for conduct and behavior. Even though somebody may be a juvenile or maybe young,
Notice the judge's shift here. Even though the crime involved an animal, the focus is actually on the livelihood of the victim. A reminder that in court, crimes aren't just about laws. They're about people's lives.
For your behavior. And even though we're talking about an animal, we are talking about a livelihood of an individual who does this for a living. And I want to make sure that that is instilled not only in Mr. Rayo Wolf, but in the public as a whole.
Yeah.
So that is where this court is coming from, Mr. Moustakis.
I appreciate that, Judge.
I reviewed the abstract of it. I think it stands for what you and I are taught at a lot of conferences. It basically says first-time offenders, when you do diversion on them, it reduces recidivism, increases their likelihood to be employed in the future.
All right. Okay. So before we even begin any further, I want to address restitution. Has that been stipulated to, or?
We stipulate to the document that was provided to me, which indicated a $15,000 restitution figure.
All right. And if I look at that.
Boom, $15,000 restitution. That's not just pocket change. This isn't a fine. This is the offender literally paying back the victim for the loss. Miss one payment, and the whole deal collapses. High stakes.
I see 15,000 even. All right. So we have $15,000 in restitution that for RAL, victim RAL restitution, $15,000, and that's stipulated to Mr. Rayo Wolf.
can say yes.
Yes.
It's not an LLC? All right. And so, Mr. Rayo Wolf, you understand that if the court does accept this deferred judgment of conviction, that part of the agreement is that you must pay every penny of this $15,000 within that period of time. And I believe, if I'm recalling off the top of my head, I do not have that DJOC up
It's
right
3
now.
years.
3 years. And so you must pay every penny on the dot, timely, in the timely payments. Timely, because if you miss one payment, that means this agreement can be revoked. You can come in front of this court for sentencing on that felony. Do you understand?
Yes.
And so you are accepting and being accountable for the responsibility of $15,000 in restitution to RAL.
Yes.
All right. Okay. So that is agreed upon and stipulated too. Therefore, Mr. Schmidt, argument and sentencing recommendation, please.
Sure, Judge.
Here's where the prosecutor brings the receipts. Literally Facebook receipts. Think about that. Social media posts were key evidence in proving the deer poaching. Who says your online flexing can't come back to bite?
When this case started, it was Detective Tex coming to me. We got in this report of this deer poach. He said he wanted to do a document subpoena of a bunch of Facebook records. And I read through it and I said, how do you identify a deer from photos? I can't comprehend that. I kind of said, I don't really believe that. And then he showed me the photos and I said, oh yeah, that's how. So we submitted the document subpoena with the photo of the deer on there. I actually thought about filing the complaint with the photos of the deer on there for exactly that reason. I didn't, because of restrictions on the Protect software. And of course that drew a motion that kind of had that as part of the motion to dismiss. The next part of it was finding out the cost of the deer. When we first got the case, I thought the cost of the deer would be like a few hundred to a few thousand, because hey, it's livestock. The high end of livestock in my mind was cows. That's like what cows are. So I was totally dead wrong. What I'm getting at is there was a lot of self-education for me, a 34-year-old educated male who grew up in a household where still, even though I don't hunt anymore, my dad talks to me about hunting all the time. I would have never guessed this is the value of the deer. When we dumped the Facebook records, we didn't see any discussion about what the cost of these animals were. Just, hey, look at this website. Look what this one looks like. What a monster. Look how big the rack is. A lot of that kind of thing. There's no evidence of any like drug use or substance abuse or that sort of criminogenic need. So we charged it out. We got the motion. I don't think it was a frivolous motion, so I don't really fault that or anything. And then I made my offer in the case, which was an either or offer depending on whether we got the head back. For me, the getting the head back was important because it's not that a deer was stolen or it was harvested in the traditional sense. The meat was left.
Listen carefully. The prosecutor points out that the head of the deer wasn't just a trophy. It symbolized the entire luxury hunting experience. This is where law meets psychology. The value isn't the meat, it's the pride.
All that was harvested is the head. And the deer is not really what this business owner sells. He sells the experience. It's a high-end luxury experience that is cost prohibitive to most people. You probably need a discretionary income equivalent to my salary from the government to be able to afford to do this. And what my takeaway from that is the value of the head is part of what people value as that experience of the hunt, because they want to get that head, they want it on the wall, they want to show people, it's a point of pride. When I saw the messages on the Facebook that we dumped, the value was the pride of it. And there was no intent to sell the head. The head, you heard from at the last hearing from the victim, has a de minimis value because it's really most valuable to whoever hunted it, whoever bought the experience. So I wanted the head to, one, I didn't want the offender to have that after whatever the conclusion of the case was, because that would be.
And here's a fascinating move. The prosecutor didn't want the offender keeping the deer's head as a trophy of crime. Imagine hanging stolen evidence on your wall. That's not just illegal, it's a permanent middle finger to the justice system.
Not just a trophy to, the hunt, it'd be a trophy to something they did wrong. I thought it could be negatively reinforcing socially. I also wanted it because turning it over prior to a plea would accomplish showing some remorse and contrition. It accomplished wanting to make things right. I had this one burglary case recently where the defendant actually helped recover the property, and that very much impressed me. So that was my first offer. It was accepted. They waived prelim to accept it. They brought the head to the prelim. They pled guilty to both counts as is without even receiving discovery. I can't imagine what more the defendant could have done to show contrition and remorse in this case. Prior to the hearing, Mr. Moustakis was back in my office and we were talking about restitution. You can probably imagine, there's a discussion as lawyers do about, well, should it be the cost or the value of it? And I was getting up the statute on my phone. And Mr. Rayo Wolf was standing next to his attorney and just kind of intervened and shut both me and Mr. Moustakis down and said, no, I did some research. I think it was worth this much. I want to stipulate to the restitution. Both me and Vicky talked afterward. We were very impressed with that he had the boldness to step in and stop his attorney trying to get him a better bargain, try to get him a reduction in cost to himself, because I get the impression he thinks it's the right thing to do. When I looked at this case originally, the thing that was the most similar in my mind to other past cases we had, when this when this animal was poached, Mr. Rayo Wolf would have been about 17 and a half. 2 years ago, we had an offender who was about 3 months shy of 17. So it was a juvenile case where they broke into a meat packing place and caused damage to it, just graffiti kind of nonsense, spraying fire extinguishers. If you had asked how much it would cost to repair that, to clean it up, you'd guess a few hundred to a few thousand. But guess what? It's a meat packing plant. They have to be FDA compliant. They have to have hyper clean everything, have certified cleaners. The restitution that wound up being $25,000 or something like that. So I thought this case was very similar in the sense that it wasn't intuitive what the actual loss to the business owner would be from what you're doing. You'd think, hey, it's one deer in a herd of over 100. Maybe it's worth a few hundred, maybe it's worth a few thousand. I don't think the offender knew this deer was worth $15,000 when he poached it. I think he came fresh from high school, being 17 and a half. I'm still just barely young enough to remember being in high school, middle school. It does not go into your comp.
This is such a critical moment. The prosecutor compares teenage punishments like detention with suddenly facing felony charges. It's a legal leap from grounding to prison time. Audience, what do you think? Is 17 too young to fully understand consequences?
Apprehension, the consequences of things, the effect of things on other people. You come from a world of timeout and detention and can't remember what my school called them, where you get written up on reports. You come from a world where you go home and you might get grounded. You might have to pay back mom for damage for stuff. You might get whooped depending on your household. To go from that to something where what Mr. Rayo Wolf has pled to in this case, he could go to prison for. To go to that is such a huge leap, and people don't comprehend that. It's not the world they've lived their entire lives. So that's why what I crafted here is what I thought is reasonable. What I've crafted here is even really only half diversionary. The felony DJOC is the diversionary component, enables him not to be convicted of a felony so young. He does have a job where he makes pretty decent income. He does tree services. He has the ability to pay this in 3 years. I really think he does. And the other half of it, he is convicted of a misdemeanor. He's going on probation. He has the possibility of expungement, but it's still a conviction. It's still probation. It still requires him to succeed on everything in that year, or else he doesn't even get the expungement because of Wisconsin case law. If you mess up on probation, even if you successfully discharge at the end, you don't get the expungement. So I think there's a lot of accountability here, and I think there's a lot in here to make him law-abiding. But I think there's also a bit in here with the DJOC element of the felony, giving him a chance of, you're not going to get absolutely blasted on your first offense fresh out of high school, the worst it could possibly be. I think that's appropriate, especially here, given I think he does feel bad about what he did. I think he just wasn't thinking. I think he had never thought about the actual impact on other people, which, yeah, that's not a good thing. But also, when you're 17 years old, people are still learning that aspect. When you talk about like marriages and people dating and expanding, they say you start with passion, you start with romance. As you get older and you're together longer, you learn compassion, you learn empathy. And it's the same, not just for love and romance, but for everybody, for learning how to interact with other human beings. It's one of those hard to learn philosophical skills that me personally, I had the benefit of taking philosophy in college and learning about that from the ancient Greeks, but a lot of people don't. I think that we do have accountability here with the criminal conviction, with the possibility of probation being revoked and going to jail, with the DJOC being revoked and possibly going to prison, definitely being convicted of a felony that would end his gun hunting forever. The tribes have kept a lot of rights in regards to hunting from their treaty with Wisconsin and the United States, but that doesn't ban bans on firearms. That's something that would come into play and I think would be highly significant and highly motivating for this offender. So I think all things together, especially with the restitution being stipulated to today, I think this is the best way to make sure that this victim gets the 15 grand. I think this is the best way to make sure Wesley Rayo Wolf doesn't do this again. I think it accommodates his rehabilitative potential.
Here we get the balancing act of justice. Accountability versus rehabilitation. The DA pushes for a deal that punishes but doesn't destroy the young offender's future. It's the eternal courtroom dilemma. Justice or mercy?
Which I think he's shown with him even going against it, what his lawyer is actively doing to make things right. I think that's so highly significant, but also making sure he's accountable. The criminal conviction accomplishes that. So for those reasons, I think our agreement's appropriate. I ask the court to follow. Thank you.
Thank you, Mr. Schmidt. Mr. Moustakis.
Thank you, Judge. I do want to correct one thing. Our agreement, and I just looked at it to make sure, on the theft, the agreement was for costs and expungement. And I don't want to disrupt what we're doing here today. Okay, but the recommendation of probation, or that he was going to be on probation, was not part of the agreement. But my client understands.
He recommended that? I didn't hear him recommend it.
I did. I misspoke. I was reading.
That's how
how I said I didn't either or offer? I'm sorry.
Even if he did, it went over my head because I know what the agreement is.
Okay, that's fine. I just want to correct it for the record. That's
I
all.
misspoke. I was
Okay.
Even if he misspoke, thanks for correcting it. I know what the agreement is, and I, for the most part, always recite what the agreement is before I do sentencing. But thank you, Mr. Moustakis.
Thank you, Judge. Mr. Wolf is really, other than this terrible lapse in judgment, he was 17 and he has not completed high school yet. But what I find about my client is he is extremely intelligent. He is extremely logical in his thoughts when he finally did come to realize the impact that it had on another individual. And one of the things that stands out to me is the last time we were here, we were in the hallway and we were waiting, and I wanted him to address the victim. And because when years ago we talked about restorative justice versus diversionary programs, it's been a change, and I was very involved in the restorative justice.
I started a program here. We have it internal in Burnett County.
And I was one of the people that started it in Vilas County. So I'm very familiar with that, and the fact that it's good for the victim to actually have contact with the defendant and allow them to have some communication. And he did allow to have some communication with my client, and I give him credit for that. And my client apologized to him personally. That's a big thing, I think, for a young...
Big moment. The defense highlights that the defendant apologized directly to the victim. In legal terms, that's restorative justice, where healing the harm matters as much as punishment. Question is, does it sway the judge?
Individual to do. And my client wanted to do that. And I find him extraordinary because without a high school diploma, he is working for a tree service, and he runs a crew for that tree service. And by next year, he'll be running 2 crews. And he works extremely hard in that business. In fact, I learned today that he's renting a home with an option to purchase it right now. For an 18-year-old, I find that rather extraordinary. And I bring these things about because we look at this diversion program that he's agreed to involve himself in, and there are a lot of public benefits here. You know, the court asked about that last hearing we were at, and some of the public benefits, it makes him accountable. It provides cost savings to the criminal justice system. And it's not about retribution for its own sake, but accountability and rehabilitation. It actually, that article that I filed talks about how diversion from a percentage perspective over the study that they did, it increases the likelihood that first-time felony offenders who are young, like my client is, are more apt to be better employed and less involved in the criminal justice system, which is another public benefit in both regards. He's learning a great lesson by what has occurred here today because of, one, the expense that he is going to have to suffer, both for restitution and in other related accounts, my fees, frankly. So he's suffering a great financial hardship, but more importantly, he came forward and said, I want to do this. What I did was wrong. And when I sat down and talked to him about the offer that was made, and I told him that, and at the time, I did not know whether or not the head was going to be available. But it was available, and he brought it here in anticipation of this agreement. I think that says a lot for his recognizing what he did and what he did was wrong. So I give him a lot of credit for that. I think a lot of older people who are seasoned in the criminal justice system would never have considered doing something of that nature. So there are long-term benefits for both the community and for my client. And I find that important. It's interesting that this article talks about, and we've I know all studied the fact that giving people felony convictions and causing the system to deal with them generally has more negative impacts, and they become more likely to have further criminal activity. And what the article says is that there's, and I'm sure the research, and we've all looked at this, tells us that the contract is important because it gives them a basis and a reason to succeed. And I think that's exactly what Mr. Wolf understands. If he fails to comply with this contract, he's going to be back here. He's going to be back here for sentencing on a felony because he's already pled to the felony. So he has a great incentive, frankly, to make sure that he succeeds in this contract. And I have no doubt that he will, in my mind, based upon the things that I've learned about this young man. He actually brought money to start paying restitution today because he recognizes that's important. And he truly is very sorry for what he has done. These diversion programs, according to this empirical data, indicate that they improve behavioral outcomes over a 10-year follow-up period. 48% of a decline in future convictions and 64% in improvement in earning capacity. That's substantial. And I think in Mr. Wolf's case, at 18 years old, he's earning more than a lot of people, and he's doing it, and he works hard, he works full-time. Really impressive, and I think this young man really ought to complete his education, because I think he could provide a lot of intelligent feedback to his community. I'm impressed by him, and I don't say that very often. I will indicate, so the court's aware, and I want to be forthright, is this empirical data was done with low-risk offenders from Harris County, Texas. They were young Black offenders, but I think that it would still ring true throughout other communities as well, that are young offenders, first-time felony offenders, as we have here. It's interesting that the article talks about the stigma of the felony conviction on these young offenders, because they recognize that they do not want to be convicted of something. And in, of course, Mr. Wolf's case, the lone fact alone that he may never be able to possess a firearm is a big stigma to him and his upbringing as a Native American. So I think when we take a look at that, that's yet another public benefit, because it reduces the negative impact of felony convictions. And it's interesting because the empirical data really suggests that the criminal justice system, and what I learned today from the state, frankly, is that the diversionary programs are judge-based and developed in Wisconsin. And the empirical data indicates that it's the criminal justice system that plays a crucial role in this particular situation, and it actually talks about racial inequality in the United States. You see, neither I nor I think the ADA or even Mr. Wolf could actually be able to afford the services provided by the victim, even with our good jobs. And that's an interesting dynamic. So
You'd be surprised who affords that, though, who actually puts the money aside to be able to do that. I'm well aware of, I'm very familiar with this type of employment and this type of business. Born, raised here in Burnett County, very familiar with hunting, very familiar with big game and these farms, especially the fact that I think we have 3 or 4 in this county,
yeah.
Game farms.
I'm not quite as familiar, but I am familiar with.
I knew it wasn't going to be worth $300 or $500. I knew it was going to be worth more of the $10,000, $15,000, $20,000 range.
Understood. Okay. But
Here comes the judge's hammer, calling the act egregious: climbing fences, killing a prized animal, posting it online. This isn't just a lapse in judgment, it's a deliberate stunt. And now the consequences are hitting hard.
just to say, the public benefits, another public benefit also suggests that these kinds of changes in how the criminal justice system is handling first-time young offenders may lead to lower rates of reoffending and higher rates of rehabilitation.
We're preaching to the choir with diversion programs.
I only raise these things because of what happened at the last hearing. Okay.
And what happened at the last hearing, and I'll get into that with my sentencing, Mr. Moustakis, because this was so very egregious and a very egregious conduct and behavior. And given it was a 17-and-a-half-year-old coming 2.5 to 3 hours from Lac to Flambeau, making the drive at night to come to a big game farm to climb a 10-foot or more fence over to get a big game buck, to kill that buck, to cut off its head, to carry that head over that fence, and to take that and then to blatantly place it over Facebook. That is the reason, because this is so egregious.
And I think that the court, with the background that the court has and the background that I have at my age, can understand that. I think a 17-and-a-half-year-old doesn't have that appreciation. And until they learn and recognize the experiences that other people have.
That's why he's in that chair right now, and that's why he gets to have the experience of you in that chair.